Okay. So, discussion ulit tayo. So, ito, basically, itong title na to, mabilisang discussion lang to kasi maikli lang naman ito sa book, sa corporation code natin. So, anong title to? Title 13, Special Corporations. Now, dito sa title 13, basically, ano lang yan eh. Dati, dalawang chapters lang yan. Dalawang special corporations lang na mention dito sa Title 13, which is the Educational and Religious Corporation. Pero since nagkaroon na tayo ng Revised Corporation Code, 3 chapters na tayo meron dito. Si Educational, si Religious, at si One Person Corporation. So, discuss na tayo. So, Chapter 1, Educational Corporations. Now, start sa Section 105. Sabi dito, incorporation. Educational corporation shall be governed by special laws and by the general provisions of this code. So, defining an educational corporation, this is a stock or non-stock corporation. Oo, pwede siya dalawa, either sa stock or non-stock, that is organized to provide facilities for teaching or instruction. Such corporations normally maintain a regular faculty and curriculum and normally have a regular organized body of pupils or students or attendance at the place where the educational activities are regularly carried on. So don't confuse this with WIMSU or other educational institutions that is under the umbrella of the government kasi under yan siya sa government, special laws yung nag-create sa kanila. Ang pinag-usapan natin dito, those private corporations. Kasi nga, pinag-usapan natin dito is the Revised Corporation Code of the Philippines, which is the General Corporation Law or the General Law that governs the creation of private corporations. So in this case, ito, may dalawang klase tayo ng educational corporation, yung stock and yung non-stock. Dito sa non-stock, an example of this is the Ateneo de Zamboanga University. Non-stock yan siya. It was not created for profit purposes. Hindi yan create para mag-conduct ng business operations. Ito namang stock corporations, these educational institutions were formed for business purposes para to earn profit. A good example of that, yung mga big universities sa Manila, yung FEU, San Beda, yun. May mga may mga board of directors yan sila. They were created for educational purposes, profit purposes, revenue purposes, para kumita. Kaya lalaki ng tuition ng mga yan. So the laws applicable as provided dito sa ating sa section 105 is the yung special laws governing educational corporations. And take note, educational corporations are different from ordinary non-stock corporation formed or organized for educational purposes, like mga foundation for mga foundation para magturo ng bata. Yun, di yung point. Different yun sila from educational corporations kasi ang educational corporations, ito talaga yung mga organized to provide facilities for teaching instruction. They operate normally. May regular faculty sila and curriculum and may regular organized body of pupils. So parang institutionalized talaga ang isang educational corporation. So don't confuse it with ordinary non-stock corporation that is formed or organized for educational purposes. Now, as what I've stated by section 105, educational corporations are governed primarily by special law and it is only supplemented by general provisions ng code. So if there's a conflict between the special law that governs educational institution or educational corporation, may conflict sa general provisions ng corporation code, ang mananaig is yung special laws. Kasi special corporation yan siya eh. Now take note, sa previous corporation code natin, sa Batas Pambansa bilang 68, meron pa tayong section 107. Itong section 107 was still existing. Basahin natin. Prerequisites to incorporation except upon favorable recommendation ng Ministry of Education. Tama? Ang tanda-tanda ng word, di ba? Ministry of Education. Kasi nga 1980 pa to na promulgate. Ministry of Education and Culture. Ngayon, Department of Education Pati ng CHED. The Securities and Exchange Commission shall not accept or approve the articles of incorporation and bylaws of any educational institution. So ngayon, wala na yan. Hindi na kailangan ng approval ng DepEd and ng CHED upon incorporation ng isang educational institution. Nasa paano yan kung hindi na kailangan ng approval nila? I-approve pa rin ba yan? Para nawala na ng regulatory purpose yan eh. Kahit niyan they will still fall under the jurisdiction of the DepEd and CHED kahit hindi na kailangan, kahit wala na yung kahit wala na yung favorable recommendation kasi may mga licensing pa sila permit to So wala yung problema sa regulatory purposes kahit tinanggal yung section 107. Ito naman, section 106, trustees of talks about the board of trustees. So as you know, board of trustees mga non-stock yan. So gaya ng sabi natin, di ba? Ang isang educational corporation pwede siyang maging stock or non-stock. So kung non-stock siya, meron siyang board of trustees. Trustees of educational institutions organized as non-stock corporation shall not be less than 5 nor more than 15. Provided that the number of trustees shall be in multiples of 5. So take note of this. Bakit? Kasi 'di ba, napag-usapan natin na wala nang minimum number of board. At least one na 'yan. At least one na lang. Pero sa board of directors maximum 15. Pagdating sa board of trustees, 'di ba? Maximum pwedeng lumampas ng 15. 'Di ba? Napag-usapan natin 'yan. Pagdating dito sa educational corporations, may specific provision in regards to that. Na stricto, dapat hindi less than 5 and dapat hindi more than 15. So hindi nila binago to. Wala silang ginawang changes pagdating sa educational corporations. So not less than 5 and not more than 15. And take note, may additional requirement pa. Provided that the number of trustees shall be in multiples of 5. So shall be in multiples of 5. Tapos not less than 5 but not more than 15. So ang choices lang na binigay para sa board of trustees ng isang educational corporation, non-stock, is to have a board of trustees in the numbers of 5, composing 5 members, 10 or 15. Yun lang ang choice nila. Now, unless otherwise provided sa Articles of Incorporation or bylaws, the Board of Trustees of incorporated schools, colleges, or other institutions or learning, shall as soon as organized, so classify themselves that a term of office of 1/5 of their members shall expire every year. So take note. Anong meaning nito? Ibig sabihin, yung mga original trustees, yung mga original, upon formation, sila yung unang trustees. Meron lang silang sila ng schedule na kung saan 1/5 of their member, yung term nila will expire every year. So ibig sabihin, let's say may 15 na trustees, original trustees that was formed. So pagka next year, yung tatlo dyan, papalitan na, expired na yung term. The next year, the year following that, the next 3, tanggal rin. Di ba? Kasi 1/5. So, let's say, pag 10 yan sila. So, na-form sila 2020. Pagka 2021, dalawa sa kanila, expired na ang term. 2022, yung next dalawa. Yung next dalawa. Until na maubos yung original trustees. Na pag naubos sila, anong mangyayari? Anong mangyayari pag na-expire na yung term nila? Ito lang, nakalagay dito. Trustees thereafter, ibig sabihin, after ng mga original trustees, elected to fill the vacancies occurring before the expiration of the particular term shall hold office only for the unexpired period. So pag naging substitute lang siya basically for the vacancy. Now, trustees elected thereafter to fill vacancies caused by expiration of term, ibig sabihin, example, 2020 na form yung corporation, 2021. So yung first batch ng 1/5 mag-expire na yung term nila. So yung papalit sa kanila, kasi expiration of term yun, will hold office for 5 years. So yun yung yun yung plano nila, staggering kumbaga. So 5 years yung subsequent. Yung mga original, 1 year, first 5, the next year yung next 5, the next year yung next 1/5, the next year yung next 1/5. Tapos yung papalit sa kanila, 5 years na. The majority of the trustees shall constitute a quorum for the transaction of business. The powers and authority of the trustee shall be defined in the bylaws. For institutions that was organized as stock corporations, the number of the directors shall be governed by the provisions on stock corporation. So sa trustees lang is stricto. Sa board stock corporations for the board of directors, so 1 to 15, 'di ba, yung max. So ito, board of trustees or directors, section 106 lays down the following rule. Ito sabi natin, for non-stock educational corporations, the number of trustees shall not be less than 5. Kaya sabi natin, not more than 15. So multiples of 5 lang pwede. So 5, 10, 15 lang yung pwedeng compose. Hindi pwede 6, hindi pwede 7. Kailangan 5 or 10 or 15. Now, unless otherwise provided sa articles yung the term of the office shall be staggered 1 year interval. Unless otherwise provided. So, pwede nila hindi i-follow. Kasi, kung ako sa kanila, hindi na i-follow eh. Masyadong hassle pa. Hassle pa yung 1/5, stagger yan eh. Magkakagulo pa yan. So, kung ako sa kanila, huwag nang i-follow. Pero unless otherwise provided, ito ang mangyayari. Trustees subsequently elected shall have a term of 5 years. Trustees that was elected to fill the vacancies na kung saan hindi expiration of term yung yung reason ng vacancy, magiging substitute lang siya for the unexpired period. So, kung may natitira pang 2 years, example, yung isang board of trustees, 3 years pa lang nag-serve, tapos namatay, so, kailangan i-fill yung vacancy na yun. So, yung substitute niya for that vacancy, 2 years lang. Since yung reason ng vacancy is not the expiration of term. A majority of the trustees shall constitute a quorum for the transaction of business, and the powers and authority of the trustees shall be defined in the bylaws subject to the provisions of Section 22. Ito naman for non-stock corporation, the number and director shall be governed by the provisions on non-stock. So, paragraph, staggering system. Okay? Now, let's go to chapter 2, religious corporation. So, kahit mga religious movements, religious beliefs, or religious religious associations, pwede silang mag-incorporate provided ng batas eh. So, classes of religious corporation. The religious corporation may be incorporated by one or more persons. Such corporation may be classified into, so dalawa tayo meron, corporation sole and religious societies. Na pag-usapan natin ito sa corporation sole, di ba? Pati religious societies, sa general provisions pa lang natin. Now, religious corporation shall be governed by this chapter and by the general provisions on non-stock corporation insofar as applicable. So, if there's a conflict between this chapter, this Title 13, and yung general provisions ng non-stock, sinong mananaig? Yung Title 13 Chapter for Religious Corporations. Ito, corporation sole for the purpose of administering and managing as trustees the affairs, property, and temporalities of any religious denomination, sect, or church or corporation sole may be formed by the chief archbishop, priest, minister, rabbi, or other presiding elder of such religious denomination, sect, or church. So ito, a good example of corporation sole natin is the Roman Catholic Church of the Philippines, which is headed by our archbishop. Yun. Another example, if I think, Iglesia ni Cristo rin nata, corporation sole. So ito, gagawa rin sila ng articles in corporation, pero di ba? Yung Roman Catholic Church natin, hindi na sila nag-file ng articles in corporation. Automatic silang naging automatic yun naging corporation sole because of existence since time immemorial. So sobrang tagal na dito sa Pilipinas, kinonsider na siya as corporation sole. So pero pag may gustong religious movement, religious association na gusto mag-incorporate, so ito yung laman. So read na lang. Ang important na ito, submission, mga important naman yan eh. Acquisition and alienation of property, filling of vacancies. Ito, pag gusto nila mag-dissolve, may be dissolved as per a corporation sole may be dissolved and it's a fair settled voluntarily by submitting to the commission a verified declaration of dissolution setting forth yung name, reason for dissolution, news address. Upon approval, the corporation shall cease on its operation except for the purpose of winding up its affairs. Ito naman, religious societies. So, ito yung another type of religious corporation. Now, unless forbidden by competent authority, the constitution, pertinent rules, regulations, or discipline of the religious denomination, sect, or church of which it is a part, any religious society, religious order, diocese, synod, or district organization of any religious denomination, sect, church, maraming wording. Upon written consent, basta nag-agree yung members nito by an affirmative vote at a meeting called for the purpose, at least 2/3 ng membership basically nag-agree na i-incorporate nila. Bakit nila kailangan incorporate? For the administration of its temporalities or for the management of its affairs, properties and estate by filing with the commission. Ito, articles, etc., etc. Kasi ito yung nilalaman. So, yeah. Di naman importante. So, definition of religious corporation. So, to for the Section 107 and Section 114 because that is the chapter for the religious corporation. Religious corporation has been defined as a corporation composed entirely of spiritual persons and which is organized for the furtherance of a religion or for perpetuating the rights of the church or for the administration of church or religious work or property. The spiritual persons that may compose ecclesiastical corporations, mga bishop sila, certain deans and prebendaries. So yan lang. Organized for the furtherance of religion or for the perpetuating the rights of the church or gusto nila administration of religious property. Kasi diba, gaya na sabi natin, furtherance of religion, perpetuating the rights of the church, or for the administration of church religious work or property. So, di ba kasi ang isang corporation may separate, distinct juridical personality siya that is separate from its owners. Di ba? Ganyan yung isang corporation. Kaya dito, gusto nila administration. Isa sa mga reasons. Now, what are the applicable provisions for religious corporation? Now, since they are classified as special corporation under this code, they should not be confused with those non-stock corporation, ordinary non-stock corporation that are organized for religious purposes. So, iba yan sila. Kasi tinatrato to silang special corporation. Kapag finalo nila yung provisions ng section 107 to 114 or basically the chapter 2 of title 13, then they should be considered as special corporations. Kapag hindi nila pinalo, ang finalo nila yung para sa non-stock ordinary corporation, yun yung mag-govern sa kanila. The corporation code does not require any religious group, sect, denomination, or denomination na mag-register. Hindi sila required mag-register. Pero yung status nila will be considered as ordinary organization or association. Without ito yung sasabi natin kanina, juridical or legal personality that is separate and distinct from that of its member. Kasi, walang separate personality eh. Ito, religious corporation primarily governed by Section 107.14. Supplementary lang yung titles ng general provisions ng non-stock corporation. As a rule, the bylaws of a religious corporation must conform with the general provisions affecting corporations. Any inconsistency shall be resolved in favor of the special provisions under Title 9 sa non-stock corporation and Title 13, Chapter 2 on religious corporations. So, ganyan lang kaikli. Ang kapag sa normal to, mga 10 minutes sa normal class to, mga 5-10 minutes tapos na tong discussion to. Kasi maikli lang naman tong Title 13. However, dito sa Title 13, dito dinagdag yung classes pa pala na-mention naman natin. Dito sa Title 13, nadagdag dito yung bagong provision. Isa sa mga big changes ng ating corporation code. So, itong one-person corporation class, this is, gaya na sabi natin, this is one of the most significant changes sa revised corporation code natin. Kasi dati, from the word itself, alam nyo na kahit isang tao lang, kahit isang entity pwede mag-form ng corporation. Di ba? Dati kasi hindi yun pwede. Kasi dati, ang required talaga is, as we have mentioned kanina, na ang required number of board members kasi, dati, siyempre yung board yung mamahala sa corporation, no? And yung required number of incorporators, yung minimum kasi dati is 5 as you have mentioned. Kaya nga, 5 rin yung minimum for the board of directors and trustees dati. Pero ngayon, since nabago na yung na-revise na yung corporation code natin, pwede na ang isang tao, isang entity, mag-form ng isang corporation. So yung incorporator natin, yung minimum number, tinanggal na yung minimum 5. Kasi kahit isa, pwede na. Basta 1-person corporation. And yung board of directors natin, di ba? Minimum 5 rin yung dati, ngayon tinanggal na rin. Yung board of trustees natin, except sa educational corporation, minimum na rin doon is 1. Kasi pwede na isa eh. Sa non-stock corporation, isa lang board of trustees. So, ano ba tong 1-person corporation na to? So, itong 1-person corporation, nagsisimula tayo sa section 115. So, sabi dito, applicability of provisions to 1-person corporations. Na maganda kasi dito, mapapabilis yung discussion natin kasi straightforward yung mga provisions. So the provisions of this title shall primarily apply to 1-person corporations. Other provisions of this code will only accept suppletorily, so supplementary lang sila, secondary, except as otherwise provided in this title. So basically, if there's a conflict, ang mananaig yung sa Title 3. Title 3. Yung mananaig dito sa Chapter 3, Title 13. When it comes to 1-person corporation. To Section 116, definition ng isang 1-person corporation. Now, ang 1-person corporation is basically a corporation with a single stockholder. As you can see here, single stockholder. Ibig sabihin, pwede lang siyang maging stock corporation. Kasi nga, sabi, single stockholder. Anong type of corporation lang ang may stockholder? 'Di ba? Stock corporation. So, ibig sabihin from that, makikita nyo na hindi siya pwede maging non-stock corporation. Kasi stockholder, klarong-klaro yung batas. Kung sinabi niya dyan na one member, edi single stockholder, single member. Single stockholder lang sinabi. Na provided that only a natural person, ibig sabihin tayo, mga tao, trust or an estate may form a 1-person corporation. No. So, hindi lang pala pwede tao ang pwede. Pwede na parang trust or estate. Now, ano ang trust? Ano ang estate? Well, if na-discuss na sa inyo sa yung taxation, nandun yung definition ng trust and estate. Pero basically, ang trust, paano natin ito explain? May space ba dito? Ang trust kasi, saan ang pen natin dito? Ang trust, ganito yan ang formation yan. Meron tayong grantor kung saan may pagmamayari siya ng property. Si grantor. Ngayon ito si grantor, sabihin natin may mga kamag-anak siya, may mga anak siya. Tapos gusto niya na before sa mamatay, at least assured siya na maalagaan yung needs ng kanyang beneficiaries, kumbaga dito mga anak niya, mga beneficiaries. Gusto niya yung needs nila maalagaan. So, in that sense, nag-decide siya na magtayo ng isang trust. Oo, trust ang tawag doon. Trust. Na kung saan dito sa trust, ilalagay niya yung mga assets niya. Lagay niya cash niya, mga stocks niya, ganun. Basta asset niya, ilalagay niya dyan. Tapos itong trust na to, may magmamanage nito. May magmamanage ng trust na to. Manage. Ang tawag sa magmamanage ng trust na to, is a trustee. Yun yung tawag sa kanya. Bakit to nagluloko ang pen dito? Trustee ang tawag sa kanya. Ngayon, sir, paano pagbuhay pa rin si Paano pagbuhay pa rin si grantor? Anong mangyayari? Kapag buhay pa rin si grantor, pwede rin siyang mag-manage ng kanyang trustee, ng kanyang trust. Okay? So ganito yan, di ba? Ulitin natin, si grantor, gusto niya ma-protectionan yung needs ng kanyang beneficiaries, mga kamag-anak niya, mga anak niya, magulang niya. So, nagtayo siya ng trust ang tawag doon, na kung saan ilalagay niya yung mga assets niya dyan sa trust, na para kahit kapag namatay na siya, buyag-buyag, assured pa rin siya na may matatanggap na benefits yung kanyang beneficiaries. Ngayon, siyempre kailangan may mag-manage yan. Ang tawag sa magmamanage na yan is trustee. Oo. Now, habang buhay pa si grantor, pwede rin siyang maging trustee niyan sa mag-manage. Habang buhay rin siya, revocable yan. Revocable to. Pwede niyang bawiin. Pero pag patay na siya, siyempre, nandyan pa rin yung trust. Tapos itong si manager, yung trustee, yun, minamanage siya pa rin yan para sa benefits ng beneficiary. So yan yung trust na tinatawag natin. On the other hand, ano tong estate? Itong estate basically, tawag dito, it is the mass of the mass property, rights and obligation of a dead person, of a decedent. Yung tawag sa dead person. That is the mass, a mass of, MASS a mass property, a mass of the property, rights and obligations of a dead person. So yan yung natira niya. Estate ang tawag doon. Ngayon yung estate na yan, may mamamahala dyan. Ang tawag doon is executor or minsan administrator, depende sa anong batas yan. Depende sa anong situation. Pero yun, administrator or executor. So yun yung difference sila. So makikita nyo para silang meron ring separate entity, separate personality. Kasi itong trust, yan siya. Yan siya. Nilagay dito yung mga asset. Itong estate, para rin sa kasi dyan yung mga assets, rights and obligations, yung liabilities ng estate, tapos i-manage siya ng isang executor. So yung mga yan, pwede yan silang mag-form ng isang one-person corporation. Pwede silang mag-form. Now, banks, quasi-banks, pre-need, trust, insurance, public and public listed companies, and non-chartered, government-owned and controlled corporation. So ano yung non-chartered, government-owned? Ibig sabihin, hindi special laws yung nag-create sa kanila. Oo. Di ba? Na-mention natin yan. Yung mga chartered, government-owned and corporation, special laws yung nag-create sa kanila. Gaya ng GSIS, SSS, PAGCOR, yan, mga special laws yung nag-create sa kanila. Kaya tawag sa kanila, chartered. Yung mga non-chartered, government-owned and controlled corporation, yung nag-create niyan, yung general law natin, General Corporation Law, which is the Revised Corporation Code of the Philippines. Kaya non-chartered ang tawag sa kanila. Now, itong mga to, they may not incorporate as one-person corporation. Bawal. Explicit lang sinabi ng batas na bawal silang mag-incorporate as one-person corporation. Provided further that a natural person who licensed to exercise a profession, so example, accountant ka or lawyer ka, hindi ka pwede mag-organize ng one-person corporation for the purpose of exercising such profession, except as otherwise provided under special laws. Basically, pag gusto mo mag-exercise ng profession mo, hindi gawa ka as sole proprietor, self-employed. Or kung gusto mo may kasama ka, yun, tawag dito? Ano yung na-discuss natin sa partnership? Yung GPP, General Professional Partnership, di ba? Pag marami kayo, gusto nyo mag-exercise profession nyo, GPP kayo. Kung hindi, mag-self-employed ka na lang. Ito, the RCC allows establishment of new investment vehicle. Kasi di ba, anong investment vehicle tayo familiar? Sole prop, partnership, corporation, cooperatives, pwede rin yun. Na as you can see, ang purpose talaga nitong one-person corporation is to make easy, mention naman natin to last time pa, sa general provisions pa lang, sa Title 1 pa lang, na para pa-delayin ba yung process ng pag-conduct ng business dito sa Pilipinas, di ba? Etong corporation, di ba, alam naman natin ano yan, malaki yan. Compared sa mga partnership, compared sa sole prop. So kahit na ikaw, isang mayaman kang tao, ikaw na mismo gusto mo mas gusto mo yung investment vehicle under a corporation kaysa mag-sole prop. Kasi alam mo, under a corporation, mas marami kang magagawa instead na sole proprietorship ka. So this revision, Title 13, Chapter 3 of our Corporation Code gives way for that possibility na mas padaliin yung pagko-conduct ng business ng isang tao. Kasi mas feel niya na mas maganda mag-conduct ng business as a corporation Kaso wala siyang hindi siya makagawa. So stuck sa pagiging sole proprietorship. So ngayon, meron na tayong Chapter 3, Title 13 para may bago tayong new investment vehicle, padaliin yung pag-contact ng business lalo na sa mga individuals. Now, one-person corporation is composed of a single shareholder na pwede maging natural person, trust, or estate. Ito, one-person corporation is not applicable to the following. Now, Section 117 provides for the minimum capital stock required by one-person corporation, which is wala. A one-person corporation shall not be required to have a minimum authorized capital stock except as otherwise provided by special laws. Dito tayo sa Section 118, talks about the articles of incorporation ng isang OPC. A one-person corporation shall file articles of incorporation in accordance with the requirements as we have discussed under Section 14. It shall likewise substantially contain, so may additional kailangan. In addition to the required one sa Section 14. Ano mga additional yan? If the single stockholder is a trust or an estate, the name, nationality, and residence of the trustee administrator, trustee yung natin, di ba? Nagmamanage sa tag ito, sa isang trust, so administrator, executor, guardian, conservator, custodian, or other person exercising fiduciary. Ano nga ulit yung fiduciary duties? It is a duty that is based on trust. It is a relationship that is based on trust. Exercising fiduciary duties together with the proof of such authority to act on behalf of the trust or the estate. Kasi sila itong mga tong namamahala, di ba, sa trust or estate. So kailangan nila ng magpakita ng proof na may authority talaga sila na pamahalaan yun. Name, nationality, residence of the nominee and alternate nominee, and the extent, coverage, and limitation of such authority, which this one pertains to the proof of yung authority ng mga to. Okay? So, silent points, accordance with requirements. Hindi na kailangan ng Section 119. Sabi dito, hindi na kailangan ng bylaws ng isang one-person corporation. Hindi na kailangan mag-file or mag-submit sa Securities and Exchange Commission. Alangan, siya ang stockholder eh. Siya pang director. Bakit siya pa kailangan niya? Siya namang mamahala eh. Kaya naman nandyan yung bylaws para gawing mas efficient yung pagpapatakbo ng corporation kasi maraming tao. Siya na lang manang dyan. Bakit niya pa kailangan ng bylaws? Enough na ang articles of incorporation niya. Ito naman, Section 120 talks about the display of corporate name. A one-person corporation shall indicate the letters OPC, so Alidin El Habi, Corporation, OPC, either below at the end of each corporate name. Okay. So, straightforward ang di ba? Ang straightforward yung Title 3 ng Title 13 ng Corporation Code natin. So, madali lang to. Dito alam pa isang oras. So, the single stockholder as director, president. So, kung sino may yung incorporator natin, which is also the stockholder, siya na rin yung magiging director at president. So, siya na mamahala ng corporation natin. Take note, may limitations to. Dito na Section 122. 122, I mean. So, the treasurer, corporate secretary, and other officers. So, mga employees niya, mag-hire siya. Within 15 days from the issuance of its certificate of incorporation by the Securities and Exchange Commission, this one-person corporation shall appoint a treasurer as corporate secretary and other officers as it may deem necessary and notify the commission thereof within 5 days from that appointment. So, treasurer, corporate secretary, and other officers. Now, take note, yung single stockholder natin, hindi siya pwedeng maging corporate secretary. Bawal. So, dapat different person yan. Different personality yan. Pero as you can see, dito lang siya bawal. Pagiging corporate secretary. Pero treasurer, pwedeng-pwede. Gaya nga sabi ito sa paragraph na to, a single stockholder who is likewise the self-appointed treasurer ng kanyang corporation shall give a bond, yung bond talaga, to the commission in such a sum as may be required, provided that the said stockholder treasurer, shall undertake in writing to faithfully administer the 1% corporation's funds to be received as treasurer, and to disperse and invest the same according to the articles of incorporation as approved by the commission. The bond shall be renewed every 2 years as often as they may be required. Sir, ano yung bond, sir? If nanonood kayo ng TV, na mga nagbabasa kayo ng news, baka familiar kayo sa concept ng bonds. So basically itong bonds na to, lalo na kapag yung tao, yung hawak niyang position, basically handles money, handles large sum of money. Yan usually yung binibigyan ng bond. Kahit sa other types of business, nire-require yan na yung bonds na yan. So basically itong bonds na to, bonds talaga siya. Let's say you're a corporate treasurer. So you handle large sum of money. So in order to make sure na kahit itatakbo mo yung money na yan, pwede pa rin mabawi yan. Paano? Example, treasurer ka. So nag-deposit ka ng bond sa, let's say nag-deposit ka ng bond sa sa SEC natin. Liyaw man tong nagloloko tong sa kaya tatagalan tayo. Sa basta SEC yan. So example, nag-deposit ka ng pera sa SEC in the amount of, let's say, 1 million peso. Nag-deposit ka ng bond. Kasi required treasurer ka, you handle large sum of money. Ngayon, dinimonyo ka. May hawak-hawak mo malaking pera eh. So, dinimonyo ka. Tumakbo ka, tumakas ka. Yun yung problema. Ngayon, hindi sila hindi magiging masyadong masakit yung ulo nila. Bakit? Kasi tinakbo mo man yung pera, nag-surrender ka pa rin ng pera sa kanila. Ang tawag doon, bonds. So, ikaw ang lugi. Lugi ka. Kasi nag-deposit ka ng bonds. The bonds ang tawag doon sa Securities and Exchange Commission. Kasi required ang batas. Bakit? Kasi you are one of the persons that handle large sum of money being the treasurer. Ngayon, may hawak kang large sum of money eventually. Dinimonyo ka. Tinakas mo. Tinakbo mo yung pera. So kahit tinakbo mo yung pera, hindi magiging masyadong masakit yung ulo nila kasi may bonds kang dineposit sa kanila in the amount of 1 million peso. So doon na lang nila doon kukunin yung ninakaw mo. So parang wala rin. Negative effect yun. Parang wala rin yung effect sa'yo. Kasi nag-deposit ka ng bonds tapos nagnakaw ka ng pera. Wala rin. Ang problema pa dyan, kakasuhan ka pa. Criminal action yan against sa'yo. Nagnakaw ka So kaya yan yung reason kaya kailangan ng bonds. Para to make sure na kahit tumakas to, yung mga taong nag-handle ng malaking pera, hindi magiging masyadong masakit sa ulo kasi doon na lang kukunin sa bonds yung kanilang, basically yung kanilang yung kanilang deposit. Kaya kung may babasa kayo na they shall deposit this number of bond, okay, ganyan yan. Kasi sa mga recruitment agency, ganyan rin ang ginagawa nila. Mag-deposit sila ng bond. Marami yan. May encounter kayong ganyan sa mga readings nyo. So basically, yun yung purpose ng bond. So, saan tayo? To special functions, basahin na lang to. Special functions ng corporate secretary. So, in addition to the functions designated ng OPC sa corporate secretary, gagawin niya rin to. So, parang similar lang, di ba, sa corporate secretary na discuss natin last time. So, responsibility niya, yung pag-maintain ng minutes, books, and records ng Corp. Notification, ito, trabaho ni corporate secretary. Now, let's go to section 124. Dito sa section 124, it talks about nominee and alternate nominee. Now, ano yung nominee, sir? Anong labot niyan sa buhay natin? Now, di ba? Nung napapag-usapan natin yung ordinary corporation, ano yung isa sa mga strengths nito? Isa sa mga pros nito? Advantages, kumbaga. Di ba yung unlimited life, basically, na kahit may mga kahit na may mga mamamatay na mamamatay or ma-incapacitate na shareholder, yung operations ng corporation magko-continue pa rin kasi the others will just take over. Hindi madadama yung operations ng corporation. Di ba? Isa yun sa mga advantages. Now, using that same concept, pag itong si single stockholder namatay or na-incapacitate, ano mangyayari? 'Di ba? Parang sole prop rin or parang partnership. Baka ganun ang mangyari. Na baka mag-stop, ma-dissolve. Dito sa Section 124 answers that problem or question or issue. Yung answer niyan, nominee and alternate nominee. Kapag may nangyari kay stockholder, ito ang mag-a-apply. The single stockholder shall designate a nominee or and an alternate nominee. Ibig sabihin, pag itong si nominee hindi available o hindi niya magampanan yung trabaho niya, si alternate nominee yung papalit. Na kung these persons who shall, in the event of the single stockholder's death or incapacity, take the place of the single stockholder as director and shall manage the corporation's affairs. So, ibig sabihin, namatay ka, na-aksidente ka, or na-incapacitate ka, na-comatose ka. Now, itong nominee mo, if hindi siya available, itong si alternate nominee, siya ngayon yung mamamahala, magmamanage ng corporation mo. Wala ka di mo yan eh. So, kailangan magmamanage yan. So, yan yung sagot. Kahit na may mangyari sa'yo, being the single stockholder, meron pa ring magkukontinue ng business affairs. Mamanage pa lang yan. Ngayon, the articles of incorporation shall state the names, residence, addresses, and contact details of the nominee and alternate nominee, as well as the extent and limitations of their authority in managing the affairs of the one-person corporation. Now, the written consent of the nominee and the alternate nominee, of course, kailangan may consent rin yan nila eh. Hindi lang basta-basta kung ayaw pa rin nila at the first place. So, kailangan may consent nila. Yung consent nila shall be attached to the application for incorporation. Such consent may be withdrawn in writing anytime. So, pwede lang yung bawiin. Revocable yan. Before the death or incapacity of the single stockholder. So, yan na. Kahit na may mangyari kay single stockholder, death man or incapacity, meron pa rin mag-continue. Si nominee at si alternate nominee. Na sir, after nyan sir, ano mangyayari? Anong gagawin ni na nominee and alternate nominee? Sagot pa rin yan ng batas natin. Section 125. Term of nominee and alternate nominee. When the incapacity of the single stockholder is temporary lang, like nakomatos siya pero nagising ulit, or nabaldado siya pero gumaling lang, the nominee shall sit as director and manage the affairs of the one-person corporation until the stockholder, by self-determination, regains the capacity to assume such duties. So, pag gumaling na siya, okay, balik na sa trabaho niya. Now, yan kapag temporary incapacity lang. Paano pag permanent incapacity na? Like, yun, nagulay na siya, naging gulay na lang siya, naging vegetable siya. Hindi na makagalaw. Paralyzed or namatay siya. Ano ang mangyayari? In case of death or permanent incapacity of the single stockholder, si nominee o yung kanyang alternate nominee, sino man sa kanila, shall sit as director and manage the affairs of the one-person corporation. Siya lang ba? Until the end? Hindi. Until the legal heirs, kung may mga anak yan, o di ba? Legal heirs or sino man, of the single stockholder have been lawfully determined and the heirs have designated. So, baka feel natin, baka gagawa naman yung showbiz industry dito sa Pilipinas, baka gagawa ng teleserye under one-person corporation kung saan namatay o permanent incapacity. So, mag-aagawan ngayon yung heirs. Sino yung mamamahala sa one-person corporation? Tapos si nominee, gusto niya, di ba? Gusto niya siya yung mamamahala. Ayaw niya lang siya yung nag-manage temporarily. So, baka gagawa ng teleserye yung ABS man yun or GMA. Surrounding one-person corporation. Nafe-feel ko. Gawin niya nila. Tapos corny pa rin. Saan tayo? Until the legal heirs of the single stockholders have been lawfully determined and the heirs have designated one of them or they have agreed na yung state na lang kasi one of them lang pwede. Kasi one-person corporation yan eh. Or otherwise, nag-agree na lang sila that the estate, yung mass property of rights and obligations ni decedent, yung namatay, kasi di ba pwede estate or trust ang maging one-person corporation. So, basically, either isa sa kanila, isa sa mga heirs, or mag-agree na lang sila yung estate, yung magiging single stockholder ng one-person corporation. Na usually, pag niyan sila mag-agree kung sino sa kanila, edi yung estate na lang para walang away or para less away. So, the alternate nominee shall shall sit as director and manage the one-person corporation in case of the nominee's inability, incapacity, date, or refusal. Siyempre, big ano yan, big responsibility yan. To discharge the functions as director and manager of the corporation. And only for the same term and under the same conditions applicable kay nominee. So, substitute lang siya ni nominee. So, yan na. Ito, temporary incapacity. Babalik si single stockholder, nagkasakit lang. Gumaling, nagko-COVID siya, buyag-buyag, o gumaling na siya, ma-perform niya pa rin duties niya ulit. Ito naman kapag death or permanent incapacity na. So si nominee, siya muna yung mamamahala ng business until yung legal heirs ma-determine. Na itong legal heirs, mag-decide sila sino sa kanila ang papalit bilang single stockholder, or pag hindi sila nag-agree or have agreed, agree to disagree, kumbaga, edi yung estate na lang yung mamamahala sa single stockholder o yung executor na estate basically. Now, paano pag nagkaroon ng change of nominee or alternate nominee, like yung original nominee or alternate nominee, niloloko na pala si hindi na sila friends ni single stockholder. So pwede mag-change provided in section 126 natin. So the single stockholder may at any time change its nominee and alternate nominee by submitting to the commission the names of the new nominees and their corresponding written consent. For this purpose, hindi na kailangan ng amendment ng Articles of Incorporation. Minutes of the books. So a one-person corporation shall maintain minutes of the book which shall contain all actions, decisions, resolutions taken by the one-person corporation. Records in lieu of meetings. Meetings. Ikaw lang single stockholder, but meeting yung sarili mo. So, baka mag-meeting ka sa officers mo, sa employees mo. When an action is needed on any matter, it shall be sufficient to prepare a written resolution, signed and dated by the single stockholder and recorded in the minutes of the book of the one person. So, recorded in the minutes of the book, si corporate secretary yan, of the one-person corporation. The date of recording in the minutes of the books, in the minutes book, shall be deemed to be the date of the meeting for all purposes under this code. Meeting ka sarili mo. Okay, self, ganito ang gagawin natin. So, reportorial requirements. So, procedural procedural. Reportorial matters na lang to. The one-person corporation shall submit the following within such period as the commission may prescribe. Yung kanyang annual financial statements that is audited by an independent certified public accountant. So, kailangan yan. Provided that if the total assets or liabilities of the corporation are less than 600,000 pesos, the financial statements shall be certified under oath by the corporation's treasurer and president. Pero usually, kahit na less than 600 yan, kuha na pala siya ng accountant, payad sila 5K para pa-audit, para pagawa ng FS nila. 5K, 10K, depende sa size ng company. Mga kuripot yun, yung mga bigyan ng 3K. Swerte na makatanggap ka 5K, mas maswerte kung 10K matanggap mo. B. A report containing explanations or comments by the President on every qualification, reservation, or adverse remark or disclaimer made by the auditor sa letter and disclosures of dealings, related party transactions, other reports as the Commission may require. So, reportorial requirements lang yan. Now, for the purposes of this provision, yung fiscal year ng OPC natin shall be that set forth sa kanyang AOI. Pero pag wala doon, edi consider din sa calendar year from January 1 to December 31. The Commission may place the corporation under delinquent status should the corporation fail to submit the reportorial requirements 3 times consecutively or intermittently, so within the period of 5 years. Ito yung isa sa mga, yung nalaman ko na may OPC na tayo, ito yung isa sa mga una kong naisip. So, paano yan? Ano magiging liability ng corporation and ng single stockholder, di ba? Kasi alam natin, sa sole proprietorship, di ba, siya lang nag-iisa. So, pwede yung liabilities ng business niya, magiging personal liabilities niya rin, di ba? Sa partnership, ang alam natin, na ang general partners natin na unlimited liability rin on his part. Pag limited partner, limited liability rin. So, pwedeng mahabol yung general partner. Same sa sole proprietorship, di ba? Pwedeng mahabol si sole proprietor. Tas ang alam natin, isa sa mga advantages ng isang corporation is the limited liability of the stockholders kasi unless otherwise meron silang kagaguhang ginawa, hindi sila mahabol ng creditors kung yung assets ng corporation na magko-cover sa liability. So naisip ko, na corporation to tapos OPC, iisang tao lang. So ano yan? Unlimited liability na ba tong corporation na to? Hindi pa. Section 30 yung sasagot. Section 130 yung sasagot niyan. Kasi sabi dito, liability of a single stockholder. Now, a sole shareholder claiming limited liability has the burden of claiming limited liability kasi corporation ang pinag-usapan natin dito has the burden of affirmatively show has the burden of affirmatively dapat papakita niya talaga showing that the corporation was adequately financed. Kailangan ipatunayan niya, properly financed naman tong corporation ko. Since properly financed to, limited liability yan. So papakita niya mga financial statements, mga transactions niya with financial institutions, di ba ganun? Ngayon, paano pag hindi niya napatunayan? Now, where the single stockholder cannot prove that the property of the OPC is independent of the stockholder's personal property, then the stockholder shall be jointly and severally liable for the debts and liabilities of the OPC. So, naging unlimited liability. And not only that, naging jointly and severally, diba? So, naging treated as one entity sila ng kanyang corporation. So, yan strict yan pagdating dito. Dapat pakita niya na adequately financed, properly financed yung kanyang OPC. Pag hindi niya napatunayan, then jointly and severally liable siya for the debts and other liabilities ng kanyang one-person corporation. So, si OPC and si single stockholder, pag hindi niya napatunayan na properly financed yung kanyang corporation, magiging solidary liable siya. Now, the principles of piercing the corporate veil applies with equal force to one-person corporation as with other corporations. So, alam natin, the piercing of corporate veils, alam natin yung principle na yan na kapag may kagaguhang ginawa yung mga mga officers, director ng corporation or ng stockholders ng corporation, tapos gagawin nilang scapegoat yung corporation kasi iniisip nila, ay limited liability to, hindi to kami mahabol, pero ginamit nila yung corporation sa kagaguhan nila. Then, the principles of piercing the corporate veil shall apply, so magiging solidary liable din sila, magiging hahabulin din sila. Hindi nila makiklaim na yung pagiging separate juridical entity ng corporation. Tawag dito. Itong section 131 and section 132 talks about the relation, paano nangyayari kapag itong itong si OPC gusto maging ordinary corporation, ibig sabihin gusto niya padamihin yung stockholders niya, o itong si ordinary stock corporation gusto niyang isa na lang yung magiging single stockholder, pwede yun. Section 131 provides for the conversion from an ordinary corporation to a one-person corporation. So, from ordinary corporation So, when a single stockholder acquires all the stocks of an ordinary stock corporation, ibig sabihin, binili niya lahat ng stocks. So sana lang yung nag-iisang may-ari ng stocks. Then the latter, si single stockholder, may apply for conversion into a one-person corporation subject to the submission of such document as the Securities and Exchange Commissions may require. So if the application for conversion is approved, then the commission shall issue a certificate of filing of amended articles of incorporation reflecting the conversion. So naging one-person corporation na. Now, the one-person corporation that was converted from an ordinary stock corporation, siyempre hindi niya matatakasan yung existing liabilities ng corporation. So, this OPC shall succeed the latter and be legally responsible for all the latter's outstanding liabilities as of the date of conversion, di ba? Same ni same doon sa partnership natin. Pag nag-dissolve, tapos gagawa sila ulit kasi may namatay na partner or may nag-withdraw, so na-dissolve yung corporation, tapos gagawa sila ulit ng bagong partnership to continue the business, then aakuin pa rin ng newly established yung previous debts ng past partnership. Same yun dito. Yung one-person corporation natin, kahit na-convert siya from an ordinary stock corporation, aakuin niya pa rin yung liabilities and responsibilities ng previous ordinary stock corporation. So, hindi niya matatakasan. Ngayon, meron din tayo na from one-person corporation, magko-convert into an ordinary stock corporation. So, dito, from ordinary stock corporation to one-person corporation, dito naman sa Section 132 provides for the conversion from a one-person corporation to an ordinary stock corporation. Kasi daw baka lonely na siya, gusto niya may kasama siyang ibang stockholder. So, i-convert niya na sa ordinary stock corporation para may kasama na siya. A one-person corporation may be converted into an ordinary stock corporation after due notice sa commission of such fact and of the circumstances leading to the conversion. Like example, baka gusto niya ng additional capital, nag-iisa lang siya . So, naisip niya na pagpapadamihin niya yung magpapapasok siya ng additional stockholders, mas dadami yung capital ng corporation. And after compliance with all the requirements for stock corporations under this code, yung napag-usapan natin, and applicable rules. Now, such notice shall be filed with the commission within 60 days from the occurrence of the circumstances leading to the conversion into an ordinary stock corporation. If all the requirements have been complied, then approve yan kay commission. Mag-i-issue siya ng certificate of filing of amended articles of incorporation reflecting the conversion. Goods pa rin. Now, in case of death of the single stockholder, yung nominee niya, yung alternate nominee, shall transfer the shares to the duly designated legal heir or estate within 7 days from the receipt of either an affidavit of heirship or self-adjudication. And then, yung affidavit, sa adjudication sa estate yan. Executed by a sole heir or any other legal document declaring the legal heirs of the single stockholder and notify the commission to transfer, etc., etc. Within 60 days from the transfer of the shares, the legal heir shall notify the commission of their decision to wind up and dissolve the one-person corporation or convert it into an ordinary stock corporation. So, may choices sila. Isipin na, pag namatay, in case of death lang, ang sabi, yung mga nominee, itatransfer na nila yung shares sa sole heir or sa estate. Tapos yung mga heirs yan, pag-usapan yan nila. Iko-continue ba natin tong business ni daddy? Or business ni mami? Or business ni tito? Business ni lolo? Business ni lola? Itong OPC niya? Or continue natin to as OPC? Or convert na lang natin to as ordinary stock corporation para hati-hati tayo mga mga stockholders. Or inisip nila, stress man tong patakbuhin, i-dissolve na lang natin, i-liquidate na lang natin. So choice nila, heirs sila . The ordinary stock corporation converted from OPC shall succeed the latter and be legally responsible for all the latter's outstanding liabilities as of the date of conversion. So same lang, hindi niya matatakasan yung responsibilidad niya. So yan yung OPC natin. Straightforward ng kanyang provisions. So, yan. Napaka-ito yung discussion natin for this topic. So, that is all. Bye-bye. Love you.